Hi everyone, very good morning and welcome back to CGB Mentors. So in this particular class we will be starting with your paper 4, that is BRBL and module B, right. So we will be talking about different kinds of acts that are important for us in this particular chapter. Let us start one by one. So which of the following is not an objective under the Prevention of Money Laundering Act 2002, right. So over here, to recover the stolen property, it is obviously not an objective. Preventing money laundering, confiscating the property derived from laundered money and dealing with the money laundering related issues in India. These are the three objectives that for that PMLA Act has been made. Now, in the placement stage of the money laundering, the criminal introduces the illegal funds into the financial system, right. So, how the criminal introduces the funds into the financial system, how it can be done? So, breaking down the large sum into smaller deposits and then depositing into different kinds of accounts, right. अलग-अलग तरीके के accounts में जब आप deposit कर देते हैं, this is how you introduce the laundered money into the system. Now, next you have money laundering activities can negatively impact the stability of the financial system. How? So, obviously, see, you will not be able to do the policy making, you will not have the judgment of what is the level of GDP, ठीक है, GDP का level क्या है, right, how much what you can say policy making needs to be done. So, yes, distorting the economy data and hindering the policy making, this is how the impact can be of the money laundering. Now, next is part A of the PMLA schedule, list offences related to what kind of offences are listed over here. So, there are serious crimes like the drug trafficking, corruption, etc. Those are listed in the schedule A, the part A of the PMLA schedule list, right. Now, next, as per PMLA regulations, what is a bank required to do? This is, they are talking about what is the responsibility of the bank. So, what is the bank required to do when encountering a suspicious transaction? So, obviously, whenever the bank is getting to know a suspicious transaction, they have to report the activity to the authorities. Now, with this, there is a little bit of explanation also. Bank must file the report called as Suspicious Transactions Report with the Financial Intelligence Unit, right. FIU is the Financial Intelligence Unit. They have to file this report when there are reasonable grounds for the suspicion. Now, the primary function of the Financial Intelligence Unit India is, क्या है primary function? Analyzing and disseminating information on the suspicious financial transaction, right. And reports are also submitted to this particular agency in relation to the PMLA compliance. Now, as per the Prevention of Money Laundering Act and the associated rule, what are the 4 key elements of the Know Your Customer policy for the regulated entity? So, customer acceptance, risk management, customer identification and transaction monitoring. So, these are the 4 key elements that should be there in your Know Your Customer policy for the regulated entities like the banking system and the other entities. Now, how often should a regulated entity conduct a mandatory money laundering terrorist financing risk assessment? Har mahine, every 6 months, every year, only when it is instructed by the authorities. Obviously, the 4th option doesn't hold true, right? Because you should not do it, you should do it every year. हर साल आपको करना चाहिए. It's not should be like whenever the authorities require it. So, regulated entities must conduct a money laundering and the terrorist financing assessment, present the results to their board of directors on an annual basis, right. So, because we have to comply with the FATF recommendations also, under the PMLA regulations, the principal officer of a regulated entity is responsible for. Now, what he is responsible for? Monitoring the transactions, ensuring compliance and reporting the suspicious activities. All kinds of things that a top management level should do. Now, under what conditions can a regulated entity rely on customer due diligence performed by a third party? So, the regulated entity can obtain customers due diligence records from a third party upon request, right. So, this is what regulated entity can rely on. Read this. Reliance on the third party customer due diligence is allowed only when the third party is regulated by the anti-money laundering, combating the financing of terrorism compliance, and the regulated entity has access to such due diligence records. Only in that case you can rely on it. Next, when a regulated entity suspects money laundering on a terrorist financing, and performs the due diligence and performing customer due diligence might tip off the customer, what action should they take? तब क्या करना चाहिए? So first of all you have to file a suspicious transactions report with the FIU, right, without performing the customer due diligence. पहले आप ये कर दीजिए, right, this is because this is very important. If the suspicion exists and performing the due diligence may tip off the customer might know about it. So in that case regulated entity should refrain from performing the due diligence and must immediately file a suspicious transaction report with the Financial Intelligence Unit India. In which of the following cases is a regulated entity not required to perform customer identification procedure? कब नहीं करना है? Selling a prepaid travel card 50 around 49,999. So in that case customer identification procedures, these are not mandatory if the transaction is below 50,000 for a non-account based customer, right. Now as for the Negotiable Instrument Act, what is the main objective of the act? So for the Negotiable Instrument Act, the main objective is to define and amend the laws related to the negotiable instruments. That is the major activity. Now which type of instruments are considered as negotiable instruments? So we have to see the examples over here, like the bills of exchange, promissory note and the checks, right. If you will see the other options, there are few things that we are not going to include, okay. Next is, what is the significance of hundis in the trade and credit transactions? So they are used as equivalents of the check, right, they are used as equivalents of the check. Just a second. Issued by the indigenous bankers. This was prevalent in the older times, right. So hundis are the traditional instrument used in the Indian financial practices. They are often serving as credit or remittances instruments. While not covered under the Negotiable Instrument Act, they are widely used and recognized by the custom. Custom means because this is the normal practice. Now what distinguishes a bearer instrument from an order instrument? Very, very important. So over here the bearer instrument can be negotiated by just mere delivery. Bearer instrument like your notes, right. Anybody and anyone who is having that particular note has got the property rights on that particular note, right. So this is a bearer instrument, so it can be negotiated by just by mere delivery, while the order instruments require endorsement and delivery. That means you have to write the name to whom you are transferring, and then the delivery would be considered as a valid one. तभी आपकी delivery जो है वो एक valid delivery मानी जाएगी. Now what defines an inland instrument as per the Negotiable Instrument Act? So an inland instrument, an instrument which is drawn or made in India and payable to person in India, right. So this is what an inland instrument is. Drawn or made in India and payable to a person in India, remember that, and it is governed entirely by Indian law. Now what liability does the maker or drawer of a foreign promissory note or bill of exchange have? What kind of liability that they have? So their liability is regulated by the law of place according to section 134 of the Negotiable Instrument Act. In the absence of contrary contract, the liability of the drawer is governed by the law of the place where it was created. If either you can have a contract where you will talk about that which act would be applicable if there is any kind of problem. But if you do not have such kind of thing, so wherever the drawer or maker resides in a foreign place, right, that law would be taken into consideration. What is the essential difference between a promissory note and a bill of exchange? So the difference is a promissory note is an unconditional undertaking, while the bill of exchange contains an unconditional order to pay, right. So promissory note means I am promising to pay, and in the bill of exchange it's an unconditional order, I am ordering you to pay, right. So that is the difference. Now who is the drawee in case of bill of exchange? So this is a person directed by the drawer to pay. Suppose I have to recover money from B. So I'll make a bill of exchange and I'll ask B that now you accept it, right. So I am the drawer, I have made this particular bill of exchange because I have to recover money from Mr. B, and I am saying to Mr. B that you have to say that okay, I am accepting this and I'll pay you. Fine. So B is the drawee. Now what distinguishes a check from other negotiable instrument? क्या distinguish करता है एक check को from other negotiable instruments? So over here it must be drawn on a specified banker and it is payable on demand. That is one thing. Now which of the following would not be considered as a capital account transaction under FEMA? So over here an Indian resident paying college fees for their child studying. This is not a capital account transaction because it is not impacting an asset, neither it is creating a borrowing for us. Okay? So that is why it will not be considered as a capital account transaction. As per FEMA, which of the following instrument is not included in the definition of currency? So gold bars is not included in the definition of currency. Currency includes currency notes, postal notes, right? Money orders, checks, draft, travelers checks, bills of exchange, promissory note, etc. Gold bars are not included as currency. Which of the following statement is true regarding foreign exchange as per FEMA? So it includes draft, letters of credit drawn in INR but payable in the foreign currency. ये include होते हैं. Remember that drafts and letter of credit which is drawn in INR but payable in the forex. Now which of the following is a correct example of repatriation to India under FEMA? ठीक है, repatriation to India under FEMA. So that means depositing foreign earning in a rupee account with an authorized dealer in India. Repatriation obviously where you are sending money to the India. So if you are depositing your foreign earnings in a rupee account, right, with an authorized dealer banks in India, that would be considered as repatriation to India. Next is which of the following best defines a person resident in India? किसको हम best define करेंगे? So see all the other requirements. Somewhere they are saying 150 days, not even 182 days. Person working abroad on a 6-month project. So we are talking about the person who is resident in India. A company who is incorporated in India is always considered as a person resident in India as per your FEMA. Okay. Now under section 13 of FEMA, if a contravention amount is not quantifiable, the maximum penalty that can be imposed is 2 lakhs. Right. If the amount is not quantifiable, penalty may go up to 2 lakhs. If it continues, an additional 5,000 per day can be levied. Now next we have, in the event that a person is found to have acquired foreign exchange or property abroad above the prescribed threshold, what are the consequences that he is going to face? So over here, confiscation and up to 5 years of imprisonment, that is the consequences he is going to face. If the value of the prescribed threshold, the person is liable to up to a penalty of 3x the amount involved. The property is obviously going to be confiscated and there is an imprisonment up to 5 years also, that is also involved. Who is empowered to file a criminal complaint for prosecution under FEMA for offences related to foreign assets exceeding the threshold value? So over here, the assistant director of the enforcement directorate or above, he is empowered for doing this. Now what is the time limit for the competent authority to decide on a seizure order or under the section 37A of the FEMA? So it is 180 days. Remember that the competent authority must confirm or set aside the seizure order within 180 days of the seizure. Now if an individual is aggrieved by the competent authority's confirmation, to which forum they can apply? So they can apply to the appellate tribunal that has been formulated, right? Now next is as per section 2 subsection 1 of your Payment and Settlement Act, which of the following is not included in the definition of a bank? क्या included नहीं है as per definition of the bank? So a payment bank licensed under the RBI Act, right? We are not including it. So a bank includes scheduled bank, post office savings bank, banking companies, cooperative banks and any other bank notified. Payments bank are not automatically included until unless explicitly notified by the RBI. Now which of the following best describes a derivative under section 2 subsection 1b of the Payment and Settlement Act? So what is a derivative? It's a financial instrument which is settled on maturity whose value is based on the underlying asset or rate, right? Now the types of derivatives we have is forwards, futures, options and swaps. Now who is designated as authority for regulation and supervision of the payment and settlements in India? So this is your RBI. RBI is the authority which is regulating it. Now as per section 4, which of the following does not require RBI authorization to operate a payment system? So a company which is accepting payment from its wholly owned subsidiary, so it does not obviously require the RBI authorization because the transaction is happening between the company and its wholly owned subsidiary in which the company has made 100% of the investment, right? So exceptions will include payments between holding subsidiary, duly appointed agents, exempted person via the RBI notification. Now under section 7 of the Payment and Settlement Act, which of the following is not a criteria considered by RBI while granting the authorization to a payment system? Not considered. Exception they are asking you, so social media marketing budget of the applicant, this is something which the RBI obviously will not consider while giving a authorization. So criteria for RBI authorization is technical standards, security procedures, fund transfer processes, financial strength, consumer protection terms, etc. Marketing budget is not included. Now under Payment and Settlement System Act, under what condition can a system provider make changes in the structure or operation of a payment system without giving a 30-day notice? So when the RBI considers it necessary in the interest of monetary policy or in the public interest, so in that particular case you can do it. So it mandates that no system provider shall cause any change to a payment system without prior approval of the RBI, and a 30-day notice has to be given. However, this empowers the RBI to waive this notice period if the change is necessary in the public interest. Now, which of the following is expressly prohibited under section 10A of the Payment and Settlement System Act? So, imposing any charge on a person making or receiving a payment through electronic modes prescribed under the Income Tax Act. Over here, remember that section 10A clearly states that no bank or system provider shall impose any direct, indirect, any charge on payments made using the electronic modes of payment like the UPI, IMPS or debit card operated on RuPay. Now under section 17 of the Payment and Settlement Act, the Reserve Bank has the power to issue directions in which of the following situations. So when a payment system or its participant is engaging or about to engage in conduct leading to inadequately controlled systematic risk, so in that particular case RBI may issue the written directions. Now which of the following statements regarding the settlement and netting is correct over here? So netting procedures, they are notified by the RBI, they override all other laws and are final and irrevocable. Remember that. See, section 23 explicitly talks about that netting of gross settlement procedures approved by the RBI are final and irrevocable even if a participant is declared insolvent, right? So it overrides all other laws. Who is legally empowered to inspect the premises and systems of payment service provider under the Payment and Settlement Act? So obviously officer of the RBI is someone who is authorized in writing, can do this kind of checking. Now which of the following is not an essential feature of simple mortgage under Transfer of Property Act? So over here remember that the mortgage is put in possession of the mortgage property and it is obviously not an essential feature. So under a simple mortgage, the mortgager binds himself personally to repay the loan, and if he defaults, the mortgagee can seek the sale of property through a court decree. However, the possession of property remains with the mortgager itself, right? So बैंक को हम possession नहीं देते हैं. In a mortgage by conditional sale, which of the following statement is true as per the Transfer of Property Act? Let us look at it. So section 58 provides that a mortgage by conditional sale is valid only if the condition like the retransfer or sale becoming void is stated in the same document that ostensibly affects the sale. There is no personal covenant for repayment and only foreclosure is permitted. ठीक है, सिर्फ foreclosure permitted है, sale permitted नहीं है. Which type of mortgage allows the mortgagee to retain possession and appropriate rents from the property in lieu of interest or principal payment? So remember that it is the usufructuary mortgage, right? So over here in this kind of mortgage, as per section 58D, the mortgager delivers possession of the property to the mortgagee who is authorized to retain it and appropriate rents or profits from the property towards interest, principal or both. Remember that. So it is usufructuary mortgage. Now which of the following statements best describes an English mortgage under section 58 of the Transfer of Property Act? So remember, in the English mortgage the property is transferred absolutely to the mortgagee with a personal covenant to repay. That is the English mortgage. Now what is the key characteristics of equitable mortgage under the Transfer of Property Act? So key characteristics is it is created by depositing the title deeds in a specified towns without a formal deed. Remember that an equitable mortgage, also called as mortgage by deposit of title deeds, is created by the mortgagor title documents with an intent to create security. It is valid in the cities like the Mumbai, Chennai, Kolkata. Now which of the following is not a valid requirements for the creation of mortgage by deposit of title deeds? So not a valid requirement, the mortgage property must be located in a notified town, right? So delivery must occur in a notified town. However, location of the property itself need not to be within a notified town. There is no requirement. Now in which of the following situation can a certified copy of a title deed be accepted for the purpose of creating a valid equitable mortgage. So in that particular case, remember this, normally original title deeds must be delivered to create a valid equitable mortgage, but courts have allowed the use of certified copies when the original is genuinely lost or adequate precautions are taken, like it has been verified by the CAIIB as well. Now under Indian law, which of the following statements about the priority of mortgages is correct? So first executed mortgage will prevail even if, जो पहले सबसे पहले execute की गई है वही prevail करेगी, even if registered after a later mortgage, it does not matter. So under section 47, the date of execution of a document determines the priority, not the date of registration. Please remember this point, this is very, very important. Now what is the key legal characteristic of an anomalous mortgage under section 58 of the Transfer of Property Act? So it is a combination of two or more type of defined mortgages. See, anomalous mortgage is a mortgage that is not one of 5 recognized type, that is simple, conditional, usufructuary, English, equitable. It usually combines features like simple and the usufructuary mortgages, thus option B is correct. Now what is the limitation period for filing a suit for foreclosure of the mortgage property? So what is the limitation period? 30 days, 30 years from the date when the money secured becomes due. Okay. So next is principle for appropriation under section 59. So when a debtor owes multiple distinct debts to a creditor and makes a payment with express or implied instructions to apply towards a specific debt, how much the creditor appropriate the payment? So over here, as per the debtor's indicated preference, remember that over here, see, section 59 of the Indian Contract Act states that when a debtor specifies the debt to which a payment should be applied, creditor must apply it accordingly. Suppose I have to pay you payment for 4 different items, so I tell you that okay, I am giving you 20,000 rupees, please apply to this particular amount. So that's how debtor's preferences would be doing. Now appropriation when no debt is specified, अगर कोई debt specify नहीं किया गया है तो what you have to do is, so section 60 permits the creditor to apply such payment as per their discretion. If the debtor has not specified their discretion, then the creditor can specify their own. Rule of appropriation where neither party specifies, so if the neither debtor or creditor makes an appropriation, in that particular case the payment can be applied in the order of time, right? जो सबसे पहले debt due होगा उसमें हम वो payment लगा देंगे. I'll suppose that the debt which has been taken first has been repaid first. Now which of the following is not a valid condition for legal assignment of actionable claim? So in that particular case, notices to the debtor is mandatory for assignment to be valid, right? For assignment to be valid, you have to give the notice to the debtor, that is mandatory thing. Now which of the following is true about the rights of assignee? So the assignee takes the claim subject to all existing equities as well as the liabilities. Remember that section 132 states that the transferee of an actionable claim takes it subject to all liabilities and equities to which the transferor was subjected. So if the debtor had a valid set off against the assigner, the same also applies to the assignee as well. Now which of the following condition is not an essential for the creation of valid pledge? So delivery of goods must be actual, not symbolic or constructive. So valid pledge create करने के लिए आपको actual में goods देने पड़ेंगे. It could not be a symbolic delivery. Next is as per the judgment in the case of Bank of Bihar, what is the status of Pawnee's right over pledge goods? क्या है? So Pawnee's rights take precedence. Government must compensate, right? So that is what the judgment has said. It held that the rights of Pawnee under the valid pledge cannot be overridden and the government must pay the compensation. So bank की right जो है वो रहेंगे. Under which of the following circumstances Pawnee is entitled to sell the goods? So once he has given the reasonable notice to the pawner if there has been a default, right? So reasonable notice देने के बाद में आप इसको बेच सकते हैं. Which of the following is not a valid mode of constructive delivery? So just mere oral assurance by the pawner is not a valid mode of constructive delivery, right? Constructive delivery में क्या क्या होगा? Acknowledgement, handing over the keys, document of the title, right? Oral assurance cannot constitute a valid delivery. And as per the Supreme Court ruling in the Standard Chartered Bank custodian, what is the Pawnee's right with respect to the accretions if there is bonus, dividend, etc. during the pledge period? So the Pawnee can retain the accretions as per the part of security. ठीक है, अगर goods pledge किए गए हैं, so Pawnee can retain the accretions as well. And these were all the questions that we had to discuss today.